Today, certainly in Maryland, is a day of reckoning and a day of accounting.
Attorney General Anthony Brown earlier this month releasing the results of an investigation into the abuse of children by priests and others within the Catholic Church. The report finds there were over 600 victims over 8 decades. The legislature lifted the statute of limitations for lawsuits by victims. We spoke with attorney Jonathan Schochor of the law firm Schochor and Staton.
The legislature took an enormous step to protect victims of sexual abuse in Maryland. They have, in effect, lifted the statute of limitations so that victims of sexual abuse in Maryland may move forward to enforce their rights in civil litigation and obtain adequate, fair, and just compensation for a tragedy that occurred.
Legislature put a cap on damages. How will that work, and your thoughts on that?
We've had caps in Maryland for many, many years. We've had caps on medical malpractice cases. We have caps on general negligence cases, so this does not surprise me. There's a cap for governmental liability, let's call it, and that cap is $890,000 and with no economic loss. And for non-governmental entities like the Archdiocese, a private school, let's say, that cap is $1.5 million, Jeff, with economic damages added.
There was discussion during the legislative session when this bill was being debated that a short phrase that was inserted in a previous state law, apparently without the sponsor of the bill being fully aware that it was inserted, not clear how it happened. But there's this phrase called a statute of repose. And during the legislative session, it was suggested that that might render this new bill ultimately unconstitutional. Are you concerned about that?
Well, everybody's concerned about everything. My view, having been an attorney for 50 years, is that the High Court in Maryland, in my opinion, will not find it unconstitutional. I think it's high time, personally and professionally, that victims of sexual abuse have some recourse, which they've never had before, and this simply permits that.
How difficult will these cases be to prove in court? If somebody comes forward, maybe they were previously barred by the statute of limitations. It's an incident that would have happened a long time ago. It's presumably something there weren't any eyewitnesses. You have a lot of experience in abuse cases. What do you see playing out in court?
Let's put it this way. I believe in the credibility of victims who are truly victims. So we have to vet our cases. One of our jobs as plaintiff's counsel is to take the victim by the hand, protect their anonymity, move forward, provide them with skilled representation, and gather the facts, gather what they say, check it against what was happening in the Archdiocese or a particular school or a scoutmaster or whatever. And then there's a credibility issue. The truth of the matter is that I do not believe personally that we're going to have a significant amount of problems proving our cases.
You're starting to run some ads directed at potential clients. I've seen at least one other law firm running ads as well. So the expectation is there could be a lot of cases, I guess.
Personally, I believe there will be thousands of cases because there is some confusion on the part of the public. A lot of the public think that this is only against clergy. It's not. This statute provides each and every Marylander who's been a victim of sexual abuse to come forward, as an example, against the school system, school teachers, coaches, prison guards, scoutmasters, the whole ambit. It's not just about the clergy.
The Attorney General is asking if there are other victims who are ready to come forward that they contact his office. You focus on civil law, but is there potential here for criminal cases?
I think there is. I think the Attorney General, in my opinion, believes that the older cases going back 80 years would be difficult for criminal prosecution. But bear in mind, Jeff, and listeners, viewers, that we're talking about civil litigation, which has a very significantly lower burden of proof for civil litigation versus criminal. Criminal is beyond a reasonable doubt, and civil is a probability of truth.
Anything else that Marylanders should know about this situation?
Certainly. As you may well know, just as an example, Jeff, I've had experience representing 8,000 women against the Johns Hopkins Hospital for an OBGYN who was a sexual abuser. Let's leave it at that. I spearheaded that litigation from inception, the beginning, to conclusion, chairman of the steering committee in a class action in that case. Represented 8,000 women, as I said, and we achieved a $190 million settlement, reported to be the highest settlement for a single sexual abuser in Maryland's history. Now, why do I say that? Because at first, many of the women that we interviewed were very reluctant to come forward.
Our thanks to Mr. Schochor.